Ora, boa tarde a todos. Como presidente do grupo e também coordenador científico do Centro de Investigação, dou-vos as boas-vindas e gostaria, enfim, eu tenho a honra de apresentar o professor Schauer. It's in English? Oh, okay, it's my bad English. We are greeting Professor Schauer that will make our annual lecture of our research center. It's a pleasure to have Professor Schauer here in the Lisbon Law School. Professor Schauer is one of the top constitutionalists and professors of theory of law and philosophy of law. We know some of their most remarking research and books, The Force of Law, Playing by the Rules, among many others. For us, we must thank very much the initiative of Professor David Duarte that was responsible by the organization of the 7th, and I won't take any more time, and it's a pleasure to give the floor to Professor Frederick Schauer. Professor, it's a pleasure.
Obrigado. Bom dia. Regretfully, I have just exhausted my knowledge of Portuguese, but you didn't come here to listen to someone butcher your language. But I am delighted to be here. This trip, this visit, this lecture has been twice postponed because of COVID. I am pleased that it is finally happening and gratified that all of you came, with thanks to the university, thanks to the Lisbon Legal Theory Group, thanks to David Duarte and all of the others who've made this possible. So with the preliminaries out of the way, let me begin. So my topic today is constitutionalism. Not this Constitution, not that Constitution, not the Constitution of Portugal, not the Constitution of the United States, constitutions in general, and maybe also some supranational understandings that have constitutional status. So much that I say may be relevant with the appropriate changes to the European Union, to the European Convention on Human Rights, and so on. And indeed, I think that much that I say is also applicable to those constitutions that are either unwritten or perhaps more accurately collections of different documents that are not encompassed in one single document. There are, at least among the developed countries of the world, only 3 of those at the moment. Only 3 countries without single document written constitutions. Those are the United Kingdom, New Zealand, and Israel. But much that I say is applicable to those as well as the vast number of other countries that have single document written constitutions. And these constitutions, these single document written constitutions in particular, are often described in grand, magnificent, majestic terms. Constitutions embody and enshrine a nation's most important values, it is said. They capture the spirit of the nation. They represent the country's ideals, hopes, and aspirations. They inspire allegiance. They operate as a civil religion, and so on, and so on, and so on. I'm not sure that any of those grand claims about what constitutions do are actually true. To some extent, these grand claims make empirical arguments or empirical claims about the causal effect of a constitution on the beliefs and attitudes of citizens, but it is far from clear that constitutions actually do that. I should note that one could give an entire lecture, not this one, one could give an entire lecture on these claims about the effect of constitutions as the independent variable, as social scientists would put it, on the dependent variable of people's attitudes. That is, do constitutions or even constitutional decisions of apex courts interpreting those constitutions actually affect what people believe, what they think is important, and so on? Maybe yes and maybe no. There's a little bit of research in my own country that suggests that maybe it's not as true as people often believe, and it's certainly an important research project that people are beginning to study. To what extent does a constitution or constitutional decisions actually affect people's attitudes? If a constitution declares certain forms of discrimination to be wrongful, do people believe more after being exposed to that constitution than before that those forms of discrimination are in fact wrongful? Do people believe that the values embodied in the Constitution are important values, and do they believe that because the Constitution says so? But as I said, that's not the topic for today, but I will at least, as it is said, plant a marker for maybe a future lecture or maybe an idea for others. My goal today, my topic today, is to address a less grand, less monumental, less glorious, but perhaps more important function of a constitution. This is the idea of a constitution as constraint. A constitution that constrains officials and policymakers, and importantly, and I will keep returning to this theme, constrains and thus blocks both good and bad officials in their pursuit of both good and bad policies. So let me start with a distinction developed most prominently by the philosopher John Searle. And this is a distinction between two types of rules. One is the constitutive rule, and the other is the regulative rule. Constitutive rules constitute in the sense that they create possibilities, they create behaviors that could otherwise not exist. Behaviors that could not exist but for the rule or but for the rule system of which a particular constitutive rule is a part. Without the rules of football, there would be no such thing as offsides. Without the rules of chess, there would be no such thing as castling or checkmate. And being an American, I should mention that without the rules of baseball, there would be no such thing as a home run. So too with law. Without the rules of law, there could not be trusts, there could not be corporations. Various other things are creatures of law. They are created by law, they are constituted by law. And so too with constitutions. Without a constitution, there would be no parliaments, no presidents, no prime ministers, no constitutional courts, And because these institutions are created by constitutions, they are constituted by constitutions, they have no antecedent or pre-constitutional existence in the same way that offsides has no existence prior to the rules of football. All of these things are creatures of the Constitution in the same way that trusts are creatures of a different part of the law. But in contrast to these constitutive rules, regulative rules regulate behavior that is conceptually, empirically, and often temporally antecedent to, prior to the rules, as a logical matter and not just a temporal matter. Consider, for example, the typical motorway speed limit. The typical speed limit in much of the world prohibits driving on the motorway in excess of 120 kilometers per hour. But the behavior that the rule regulates does indeed have an antecedent conceptual existence and an antecedent conceptual and empirical possibility. It is possible, without any rules, to drive at 140 or to drive at 160, but the speed limit operates on rather than creates the behavior. The do not walk signs at an intersection regulate the antecedently possible act of walking, just as the rules that prohibit murder operate on rather than create the possibility of one human being killing another. Once we are in this universe of regulative rules, we can see that regulative rules might regulate not only behavior, but also other rules. There are some rules whose use might be prohibited by another rule, and other rules whose use might be required by another rule. This is the idea that the great English legal philosopher H.L.A. Hart developed in talking about primary and secondary rules. Primary rules are the rules that govern behavior, such as speed limits and rules against murder and rules against theft and so on. But secondary rules, according to Hart, are the rules about the rules. Some rules, Hart said, are rules of adjudication. They are the rules that determine how we will interpret the rules, how we will resolve disputes about interpretation and application of the rules. There are also secondary rules of change. How will the primary rules be modified? How will they be eliminated? How will they be amended? And so on. But for Hart, most importantly, among the secondary rules were the rules of recognition, the rules that determine which rules are validly part of a system and which rules are not, which rules are recognized as valid rules and which rules are not. So, for example, it is a social rule that when you get a gift, you are expected to send a message or a letter of thanks to the person who sent you a gift. But no legal system that I know of will allow a cause of action, will allow a remedy by an aggrieved gift giver against a rude gift recipient who has not sent a thank you note or a thank you note message. The rule requiring thank you messages is indeed a rule, but the secondary rule of recognition in most legal systems says that it is not a rule recognized in that legal system. So constitutions can be recognized as systems of secondary rules. Constitutions are, among other things, collections of the rules about the rules that legislators, executives, and administrative agencies can make and enforce. So it's useful at this point to bring into the analysis Joseph Raz's idea, related to Hart's about secondary rules, of second-order rules and secondary reasons, of which for Raz the most important is the idea of an exclusionary rule. A rule that says that although something is in fact a rule, there is another rule that excludes it from consideration in some context. An exclusionary rule says that some other rule will not count. It is excluded from consideration. Indeed, we might supplement Raz's idea with the idea of an inclusionary rule, a rule that would allow or require that which would otherwise not be a legitimate part of some decision-making process. Insofar as constitutions contain inclusionary and more commonly exclusionary rules, they not only constitute, but they also regulate. Constitutions which contain rules regulate other rules, some of which might otherwise be permissible legal rules. A constitution is, in part, a collection of second-order rules excluding from consideration, excluding from validity, what would otherwise be good and valid first-order rules. The foregoing can be made clearer with some concrete examples. So let me take an example from another area of long-standing interest of mine, the constitutional law and the philosophy and the positive law of freedom of expression. Let us assume correctly that some categories or varieties of expression are not only consequential, but are harm-producing. It turns out that most second-order constitutional rules protecting or guaranteeing freedom of expression, such as, for example, Article 10 of the European Convention on Human Rights, will invalidate at least some laws and some official actions that restrict harm-producing expression. They will prevent parliaments, they will prevent nations, they will prevent executives, they will prevent administrators from taking actions against certain forms of harm-producing behavior. Or consider a rule that mandates certain forms of defendant-protecting procedures in the criminal law. Rules excluding illegally obtained evidence. Rules, as exist in many places, guaranteeing the privilege against self-incrimination. Rules requiring proof beyond a reasonable doubt for a conviction. Such rules will allow some genuinely guilty and genuinely dangerous people to escape punishment, again to the detriment of the general welfare. And a rule mandating equality may prohibit some otherwise sound and welfare-enhancing official decisions. Indeed, the same phenomenon applies to the constitutive and structural parts of a constitution. The rules that constitute and regulate parliaments and that determine what parliaments can do and how they must do it may impede otherwise desirable executive actions or even military actions. And the rules that require supermajorities for some legislative acts may prevent the pursuit of some wise policies that have majority, even if not supermajority, support. So let me generalize from this. Under the picture of a constitution that I offer here, constitutions impose second-order constraints on first-order policy preferences and first-order policy decisions. In doing so, they make ineligible, impermissible, improper, as the examples given above indicate, some number of what would otherwise be good, wise, sound, or otherwise desirable governmental decisions. In impeding bad governmental decisions, constitutional rules, being necessarily general, also impede some number of good governmental decisions. Indeed, if you take away nothing else from what I am saying this afternoon, it is the idea that constitutional rules block not only bad decisions, but good ones, and do so in the service of certain deeper or longer-term values. This picture of constitutionalism stands in contrast to two other and quite different common visions of constitutionalism. Under one of these alternative visions, constitutions and constitutions bring out the best of us and embody in a document and its application our best and most important ideals, hopes, and aspirations. Constitutions under this vision are forward-looking and also upward-looking and optimistic. This vision of constitutions and constitutionalism is in contrast to the more constraining and consequently more pessimistic vision I've just suggested. Second, there is a vision of constitutionalism, certainly understandable in light of recent and not so recent events throughout the world, that sees constitutions as being principally focused on preventing misguided, evil, incompetent, and corrupt officials from doing misguided, evil, and mistaken things. Now, if doing so is of course desirable, that is, keeping them from doing so is of course desirable. But the vision I offer here goes further. This alternative vision sees constitutions as preventing even enlightened, wise, honest, and competent officials from pursuing genuinely wise and beneficial policies, but doing so in the service of deeper or longer-term values. Constitutions, in this sense, are an example of what decision theorists, economists, and others refer to as second-best thinking. Under a first-best approach, constitutions would be drafted, interpreted, and enforced to empower the best leaders to make the best decisions. But history teaches us that the same mechanism and the same institutions that would enable and empower the best officials to make the best decisions would also and necessarily enable and empower decidedly inferior officials to make decidedly inferior decisions. Institutions, by their nature, are not and cannot be person-specific or decision-specific, and thus creating institutions to empower the best leaders and the best decision-makers will necessarily also be to create institutions that empower and enable the worst leaders and the worst decision-makers. If we wish to avoid empowering and enabling the worst officials and the worst decision makers, we must, as most constitution makers recognize, create institutions of constraint that will constrain the worst officials. But, and to repeat, and the necessary corollary of what I just said, doing so, constraining the worst officials, will also and inevitably constrain the best leaders, the best officials, and the best decision makers. When we establish institutions to constrain and impede bad officials from doing bad things, we also constrain and impede good officials from doing good things. This again is a familiar point in decision theory. Statisticians often talk about type 1 and type 2 errors. Ordinary people, those of us who are not statisticians, often talk about the same thing in the language of false positives and false negatives. In the context of official empowerment, the type 1 error is the error of failing to empower good officials to make good decisions. This is the false negative, negating a certain form of power, but falsely negating it because actually it would be a good exercise of that power. But the type 2 error, the false positive, is the empowerment of bad officials or the empowerment of bad decisions. The reverse, the false positive, empowering people to make bad decisions and therefore doing so, in effect, falsely. But regardless of the terminology, we cannot, in an imperfect world in which we operate under conditions of uncertainty, minimize both the type 1 and type 2 errors. We cannot minimize both the false positives and the false negatives. Rather, it is necessary to determine in advance which error it is most important to avoid. When we've made that determination, we can then design institutions and procedures aimed at minimizing, or at least reducing, the type of error we deem more serious, even as we recognize that reducing the type of error we deem more serious will increase the frequency and likely the consequences of the error we have judged to be less serious. William Blackstone, 250 years ago, plus or minus, observed that it is better that 10 guilty people go free than that one innocent be punished. And in doing so, he captured in the context of the criminal law a message of far wider application. We have decided, or at least most advanced legal systems have decided, that imprisoning, or in Blackstone's time, executing, imprisoning innocent people is far more serious than not imprisoning guilty people. And therefore, we have designed our system to avoid, or at least minimize to the best we can, imprisoning or punishing the innocent, even as we do so, and even as those procedures for doing so guarantee that we will increase the number of errors of actually freeing or not punishing the guilty. And so it is with constitutions, constitution making, and opposing visions of constitutionalism. When we are most concerned with avoiding the error of preventing good leaders and good officials from doing good things, we must accept that our institutions will empower less than good leaders and less than good officials to do less than good things. When we are most concerned with avoiding the error of preventing good leaders, that is, when we are most concerned with allowing good leaders and good officials to do good things, we must accept that our institutions will allow less than good leaders and less than good officials to do less than good things. Conversely, if we are concerned, as we often are in the modern world, and maybe not enough, with keeping poor officials, the corrupt, the power-hungry, or the simply incompetent from making poor decisions, then we must accept that the institutions we create to prevent or at least minimize that outcome will also stand as a barrier to good officials making good decisions. Most constitutional decisions and most constitutional structures in most of the developed industrial democratic world appear to be modeled on this latter vision. And that is why my own country, one of the most distrustful of official power countries in the world, we see officials disempowered from restricting even the most virulent forms of racist and other hate speech for fear that officials might use the power to suppress the speech of mainstream political opponents. Similarly, fearing that corrupt officials or misguided officials will support religions of which they approve and not support religions of which they disapprove. Many countries, and perhaps most extremely the United States, have strong barriers against official financial support for religion, including many forms of financial support that are beneficial. So too, with the prohibition on even benign, well-meaning forms of racial discrimination, affirmative action, for fear of the evils of less benign forms of discrimination. Now, the United States, my country, is extreme in many respects, but one of the things that it's extreme, as the political scientists have identified, is that the United States, along with a few other countries, Australia being one of them, usually is at the top of the list of distrust of government. Americans distrust their government more than do the citizens of countries that are far more worthy of distrust than the United States is. The United States, Australia, and a few others for various historical, political reasons are at the top of the list for distrust of government. And thus, in the United States, more than in other places, but hardly uniquely, we create constitutional structures and constitutional decisions that constrain good officials from doing good things for fear of less good officials taking less good actions. This is the constitutionalism of constraint, and although one might plausibly argue against it on normative grounds, it is hard to deny descriptively its pervasiveness. Once we recognize that constitutionalism may require constraining good officials from making what appear to be good decisions, we can understand that constitutions are highly unlikely to be self-enforcing. Consider an example from the United States. In 1989, in a Supreme Court case called Texas versus Johnson, the United States Supreme Court interpreted the First Amendment's protection of freedom of speech, freedom of expression, as prohibiting punishment for desecrating the American flag, typically by burning it. Almost immediately thereafter, the United States Congress enacted, by an overwhelming majority, something in the vicinity of 450 to 18, and by an overwhelming majority, a federal statute virtually identical to the Texas statute that had just been invalidated, that had just been declared unconstitutional. The members of Congress who voted for the bill knew that the law was also going to be invalidated as unconstitutional, and that is in fact what happened. But these legislators recognize that there is no political advantage in siding with the flag burners. And in fact, not a single member of Congress appears to have suffered any political disadvantage for voting for a law that they knew when they voted for it was plainly unconstitutional and destined to be invalidated. Just as there is no political advantage in siding with flag burners, nor is there any in siding with child pornographers or criminal defendants generally, two other areas in which in the United States and many other places, legislatures by large margins pass laws that in the United States is under the prevailing law clearly unconstitutional. So, for example, as anyone who knows anything about American law, or more accurately, anybody who watches television, even if you know nothing about American law, under American law, the police are required to give a so-called Miranda warning, warning those who are arrested of their right to remain silent, the fact that anything they say can be used against them, their right to a lawyer, and their right to a free lawyer if they cannot afford to pay one. In 2000, Congress passed the law essentially overruling the Supreme Court decision in Miranda versus Arizona. The members of Congress who voted for the law recognized that they didn't have the power to do this, that Congress did not have the power by legislation to overrule a Supreme Court constitutional decision, but they did so anyway, recognizing correctly that it's good politics to stand up for the police and against criminal defendants, even if the law was likely to be declared unconstitutional, which in a case called Dickerson versus the United States, indeed it was. And once we understand that the very officials whose actions a constitution seeks to constrain will have strong political incentives to avoid that constraint, it becomes apparent that we cannot expect a constitution's constraints to be self-enforcing. If constitutional constraints cannot be self-enforcing, then we can understand that the constraining Constitution is in need of various forms of external enforcement. So let me briefly talk about four of them. One, it is no accident that in the era of active constitution making and remaking, an era that goes back about 50 years or so, no country, not one, has followed the lead of the United Kingdom in relying on an unwritten constitution. Perhaps the model of an unwritten constitution will work for systems with deeply ingrained and deeply internalized constitutional values among officials and the public. But the rarity, almost the obsolescence of the UK, New Zealand, Israel model suggests that today's constitution makers understand that written constitutions will be more effective at constraints than unwritten ones. We all recognize that frequently we have desires to do something about our unpleasant habits or unhealthy habits. Maybe we make resolutions to eat less or smoke less or exercise more, and so on and so on and so on. But when we do so, one of the things we often do is write them down. The very fact of writing them down, as a number of different psychological studies have made clear, the very fact of writing something down makes it more likely to be effective in constraining our behavior than if we have not written it down. And so too with constitutions, whose very writing will make it as a psychological matter at least somewhat more difficult for officials and even the public to avoid the Constitution's constraints. If you don't write something down, if you say, I am going to eat less, and you just say it to yourself and don't write it down, then when there is that piece of chocolate cake in front of you, or the second order of pomme frite in front of you, you will come up with an exception on the spur of the moment, saying, well, this is different, it's a special occasion. This is different because I had a small breakfast this morning. This is different because I am going to run tomorrow morning to make up for it, and so on and so on and so on. If nothing is written down, it becomes easier to amend it in your head by adding exceptions, qualifications, caveats, and exclusions at the moment of application, enabling you to do what you want to do at that moment. On the other hand, if you've written it down, and if you haven't written down the exercise tomorrow morning exception, the chocolate cake exception, the special occasion exception, the small breakfast exception, and so on and so on and so on, you will discover that looking at this exceptionless written document makes it somewhat harder, not impossible, but somewhat harder to avoid what the written resolution told you to do. And as I said, there is a fair amount of psychological experimental research that supports that conclusion. Not only is writing more constraining, typically, than not writing, but writing with great specificity and precision is likely to be especially constraining. So consider Article 35 of the Constitution of the Republic of South Africa. Drafted in 1994, ultimately it became effective in 1995. Article 35 describes in great detail, even to the number of hours and the methods of dealing with the expiration of those hours when the courts are not open, how and when those arrested must be brought before a judge for preliminary determination of the validity of the charges. Given South Africa's pre-1995 history under apartheid, such precision is hardly surprising and stands in contrast to, for example, the simple requirement in the Sixth Amendment to the United States Constitution that defendants have a right to a speedy trial. And thus here, and generally, the greater the precision, the greater the likelihood of compliance, and the greater the ease of enforcement. So here's another South African example, and again I contrast it with the American. The South African Constitution, like most constitutions, deals with equality, but the United States Constitution, in relevant part, dating in this part from 1868, provides that there shall be equal protection of the laws. By contrast, the Constitution of South Africa specifies that specifies a prohibition on discrimination on the grounds of, quote, race, gender, pregnancy, marital status, ethnic or social origin, color, sexual orientation, age, disability, conscience, religion, culture, language, and belief. That which the U.S. Constitution deals with in broad general terms, South Africa deals with in quite precise terms. Indeed, we might generalize this a little bit by recognizing that although there are some constitutions that are short and vague, the U.S. Constitution is one. The 1982 Canadian Charter of Rights and Freedoms is another. Most modern constitutions are far more detailed and far more specific. In the same size type that the Constitution of the United States is 12 pages, the Constitution of South Africa is 114. The Constitution of India, much more than that. The Constitution of Brazil, much more than that. And the not ever finally enacted, proposed Valéry Giscard d'Estaing Constitution for the European Union was supposed to be something in the vicinity of 540 pages. Constitution making is progressively ever more detailed. And we see this outside of the area of constitutions as well. So some years ago, the American state of Montana attempted to replace its numerical speed limits with a simple requirement that driving be at reasonable and prudent speeds. No numerical speed limits, just signs and laws saying driving must be reasonable and prudent. That experiment lasted about a year. People recognized that not only did different drivers, but different police officers and different traffic court judges had very different notions of what was reasonable and prudent. And the reasonable and prudent idea was quickly abandoned and reverted to numerical speed limits, recognizing that precise numerical speed limits are likely to be far more constraining than broad general language. Indeed, one of the things that one sees occasionally in the U.S. are speed limits, especially in small areas, that are not designated in terms of the common increments of 5 or 10, but something in between. When you see a speed limit, I'll convert this to kilometers per hour. When you see a speed limit that says 100 or 110 or 120, it looks ordinary, it looks conventional. If you see a sign that says speed limit 97 or 114, you are much more likely to think they must really mean it. And therefore, again, there is experimental work that indicates that these kinds of unusual numbered speed limits are far more constraining than the conventional increments of 10 or occasionally 5. Third, because the avoidance of constitutional constraint is so often politically or socially advantageous. Think again of the flag burning example, the laws about criminal defendants, and so on. Constitutional constraints will be effective only if they are backed by sanctions for disobedience. Such sanctions might include monetary penalties, officially imposed political disabilities, and even the possibility of imprisonment. But if there are no penalties at all, then we should not be surprised when the official that a constitution seeks to constrain will conclude that constitutional disobedience is a cost-free strategy. Plainly, different cultures will vary in the extent to which, within the culture, violation of the law, just because it is the law, is a source of condemnation. Indeed, as I travel around the world, and I do a fair amount of traveling and look forward to doing post-COVID a fair amount of more traveling, I engage in my own form of non-systematic empirical research. I try to observe what people do in the presence of a "don't walk" sign when there are neither cars nor police officers in sight. So one of the things I've observed over the last several days is that people here in Lisbon, like people in the United States, if they see no cars and no police officers, they feel free to ignore the "don't walk" sign. A few weeks ago, I was in Vienna, When the Viennese see a "Don't Walk" sign, even if there are no cars and even if there are no police officers, they stand obediently at the corner and wait for the sign to change. So too in much of Scandinavia and other places, the difference among countries in the extent to which people feel an obligation to follow the law just because it is the law generalizes to constitutions as well. If constitutional violation is seen as an independent wrong deserving of condemnation, the more that external methods of enforcement, including penalties for the very act of violation, independent of the good or bad consequences of the violation, will become necessary. And fourth, as should be apparent from the foregoing, a necessary corollary of this is that there should be external mechanisms of constitutional enforcement. In the 1920s and 1930s, Carl Schmitt and Hans Kelsen debated about the guardians of the Constitution, with Schmitt arguing that the executive is the most appropriate guardian, and Kelsen arguing to the contrary, that an independent court, especially a constitutional court, is necessary for effective constitutional enforcement. History has plainly sided with Kelsen, the architect of the widespread institution of the specific jurisdiction constitutional court. And that institution reflects the widespread belief that leaving constitutional constraints in the hands of those whose actions and decisions are to be constrained is extremely unlikely to be effective. Just as leaving our resolutions to lose weight or exercise more are unlikely to be effective if we are the enforcers of our own resolutions, so too constitutional constraints are unlikely to be effective if we leave enforcement to the very people who we expect to be enforced. So I have focused here on constitutions, constitutional law, and constitutional constraint. But many of the same considerations apply to law in general. Just as constitutions impose second-order constraints on some even good or wise or sound first-order legislative or executive or administrative decisions, so too does law in general impose second-order constraints on even some sound or wise or good decisions or actions by ordinary citizens. And when we are thinking about law in general, many of the same mechanisms of constraint will be necessary in order to make the rule of law a reality. Constitutional law may be substantially about politics, but it is also substantially about law qua law. And we should not be surprised if many of the considerations applicable to the effectiveness of the specific case of constitutional law are applicable as well to the general case of law, whenever and wherever law shall appear. I thank you for your attention. I invite your questions, comments, objections, personal abuse, or whatever you think is appropriate. Obrigado.